We will go on the record in the matter 24 CF 119, State of Wisconsin versus Jeremiah Wagner. The state appears through District Attorney Kevin Schmidt in person. Mr. Wagner appears in person with his counsel, Joel Feliski. We're set today in this matter for a plea and sentencing. Yesterday, we were here in court for a final pretrial. The court was informed of all of the information that the attorneys are aware of. District Attorney Kevin Schmidt updated the court that based upon information he's received from Sawyer County, another county connected to this case in some way, that the facts and the evidence that Burnett County has in order to try Mr. Wagner means that the possession with intent methamphetamine is not reliable or accurate in this case as it relates to Burnett County and Mr. Wagner, and that it is just a simple possession of methamphetamine, an I felony case, and that's all accurate and true, Mr. Schmidt?
The information that New Richmond and Sawyer were using and to get their search warrant, they actually thought Mr. Wagner and Ms. Russ were in St. Croix County. They didn't know how to use the GPS equipment correctly, so they hadn't updated it. They have no explanation for why he was in Washburn heading into Burnett County. They were surprised he had meth on him when we arrested him, given the meth they thought they were going to find, they did find in St. Croix County. All of the information that when I charged this case and I was preparing to prosecute it, that I thought would show this was possession with intent, I thought was related to this quantity here. It's not. It's for the quantity found in St. Croix County.
Okay, so this is just a possession of methamphetamine, simple.
Yes.
Okay, formal motion to amend count 4.
So made.
And count 5. Let's just amend them both to simple possession of methamphetamine because that's what they are.
And the second quantity once weighed was like 0.5 gram. Most of that weight was the container. It was like one of those metal pill bottles that hangs off of a keychain.
Oh, makes sense. So counts 4 and 5 are amended to simple possession of methamphetamine, I felonies. Mr. Feliski, you have a plea questionnaire?
I do, Your Honor. I've reviewed the agreement with Mr. Wagner and have completed a plea questionnaire with him. He's agreed to plead to count 4 and 24 CF 119 as amended, with the parties making a joint recommendation for withheld sentence and 2 years of probation, the remaining counts to be dismissed and read in. As I have stated, I have a completed plea questionnaire with me. May I approach?
You may. Thank you.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What started as a case that prosecutors believed involved drug distribution has just taken a dramatic turn. After reviewing new evidence from another county, the state has backed away from the much more serious allegation and reduced the charges to simple possession of methamphetamine. That kind of change can completely reshape a sentencing hearing and dramatically affect a defendant's future. But here's the big question. Was this simply a correction after new evidence came to light, or did investigators initially overestimate the strength of their case? Stay with us, because the judge is about to carefully question the defendant before deciding whether this plea can legally move forward.
Mr. Wagner, I have in front of me the plea questionnaire waiver of rights form. Is this document the document your attorney went over with you?
Yes.
And did he go over it essentially word for word?
Yes.
And that's your signature on the second page?
Yes.
You were pleading guilty to 1 count of possession of methamphetamine. Is that correct?
Yes.
You're 31 years old. You have 11 years of schooling. You can read, write. You understand the English language.
Yes.
Did you understand everything on this document?
Yes.
No drugs, no alcohol, no medications, no mental illnesses or disorders?
No.
And did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on the first page of this plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes.
And do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Do you understand that the state would have to prove on or around May 15, 2024, that you possessed a substance? The substance was a controlled substance, methamphetamine, and you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or up to 3.5 years of incarceration, or both?
Yes.
You also understand that there is an agreement here for a recommendation to the court for probation. Do you understand that I'm not bound to follow that?
Yes.
Said differently, that if I thought the facts of this case warranted it, I could sentence you to the maximum possible penalty, and I could do so here today.
Yes.
Do you also understand that your plea to this case doesn't affect or have anything it relates to, but the plea to this case has no determination of any outcome in the St. Croix County matter?
Yes.
Okay. Do you have any questions for the court or your attorney before I proceed?
No.
Did your attorney go over that criminal complaint with you?
Yes.
That original charging document where it basically says what happened that day and why you were charged with the crimes in Burnett County?
Yes.
For the most part, as it relates to simple possession of methamphetamine, are those facts accurate?
Yes.
Are you pleading guilty to possession of methamphetamine because you are guilty?
Yes.
Mr. Flisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you other than this agreement for you to plead guilty to this charge?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Do you have any questions for this court or for your attorney before I proceed?
No.
As to amended count 4, possession of methamphetamine, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 4 in 24 CF 119. The remaining counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
Thank you. Like I said, for the statement on the public interest and for the basis of the amendment, I think for simple possession, supervision is appropriate. I've explained why I'm doing this as simple possession. I'd ask the court to file the agreement. Thank you.
All right. Okay, Mr. Falisky.
Thank you, Your Honor. I'll first address the issue of credit. Review of CCAP indicated that Mr. Wagner was brought into custody on this charge starting on May 15th of 2024, then posted bond on June 17th of that year. He was then brought back into custody again on October 22nd of 2025, then reposted bond and was released on November 24th of 2025. By my math, that would be 68 days of credit all told. Your Honor, I agree with the state that this is an appropriate resolution. Considering the facts and circumstances of this case, I think that probation is appropriate given the my recollection, the limited prior history of Mr. Wagner. I think that the community will be sufficiently protected by both supervision that probation can be relied on, as well as the resources that they can provide to address any underlying issues that may have caused or led or escalated up to this moment. I would also note in regards to Mr. Wagner's character that he is here today accepting responsibility for a serious offense. This is a felony plea. There are certain rights, such as the right to vote, the right to own firearms, that Mr. Wagner, as well aware of, he no longer has access to, that by entering this plea that he has accepted responsibility for, he can no longer own a firearm for life. He can no longer vote in any election until he has his civil rights restored. And yet here today, he is accepting responsibility because he understands the need to do so, the need to move forward from this and build back up from this. I would note additionally that in the time that I've been representing him, he's been very consistent in wanting to have this matter resolved. It was unfortunate that we weren't able to reach an agreement to have this matter resolved globally, so to speak, with St. Croix, but nonetheless, when we were given new information and a new offer, Mr. Wagner readily accepted that after discussing the matter with me. I'd also note that he did indicate to the court that he does have employment. I believe it would be full-time through construction. So he's already doing what he needs to do as far as what probation would be expecting him to do to reintegrate back into the community. Overall, Your Honor, I do think this is an appropriate agreement under the Galleon factors. It's appropriate given the nature of the offense, protects the community, and it's appropriate given the needs and character of Mr. Wagner. I'd ask the court to follow it. Thank you.
Now, does he have a criminal history in Wisconsin, Minnesota, anywhere? This is your first,
I have a DUI in Minnesota.
that's it?
That's it.
Okay, all right. And with whatever's going to happen in St. Croix County is going to happen in St. Croix County. Mr. Wagner, is there anything you want to let the court know? You want to say as it relates to this matter or any matters or any changes you've made since May 15, 2024, almost 2 years ago?
No.
No, okay.
This is where the hearing takes a fascinating legal turn. Up to this point, the court has confirmed that Mr. Wagner knowingly entered his guilty plea, but sentencing is where judges evaluate far more than just the charge itself. They look at the defendant's criminal history, personal rehabilitation, accountability, and whether the agreed recommendation truly serves justice. Notice something important here. The judge openly acknowledges that this case looked much more serious on paper than it actually turned out to be after prosecutors corrected the evidence. That's a reminder that courtroom decisions are based on verified facts, not first impressions. What do you think? Should someone who appears to have turned their life around receive probation instead of jail? Or should every felony conviction result in harsher punishment? Let us know your thoughts in the comments.
At first blush, when looking at this case and in the black and white, it looks far more serious than what it is washing out to be. Again, at least in this case, I don't know what they have in St. Croix County. I don't know what's going to happen there. I can't even look at that case as it relates to sentencing and this matter. Possession of methamphetamine alone is serious. It's a felony. It indicates that at least at that time, almost 2 years ago, you may have had a substance abuse issue. You may have been using methamphetamine. Today, it doesn't look like you are engaging in those things.
No.
It looks like you are sober. Do you want to tell me anything about that? It's got to have been a journey, a path.
I mean, yeah, just I don't use drugs anymore. That's, yeah.
What did you choose? Yourself?
But yeah.
Well, that's good. I'm glad to hear that, Mr. Wagner, because this was, again, as it appeared to be a far more serious case. And the fact that at one time you absconded for a lengthy period of time with a warrant, that made it appear even more serious in that you weren't going to take accountability for your actions and your conduct. But now as it's flushed out, this is a simple possession of methamphetamine. You appear to have been doing work on yourself and perhaps work on your relationship, and you're building something else instead of going down this path. So the court will place you on probation for the period of 2 years. I'm not going to do a withheld sentence. This is your first conviction, and quite honestly, with me, in my case, in my county, with these facts, it's not a prison case. So I'm not going to even do an imposed and stayed prison sentence with these facts and these facts alone, the court is going to do a 6-month imposed and stayed jail sentence. So if you are revoked, then you will come and you will sit this time for 6 months. You have 68 days of jail credit, I believe is what Mr. Feliski had said. The court is going to order $1,500 in fines and fees and all of that, including the surcharge. The rest of the cash will be remitted back to the poster, which is a lot of money. So you should get that back and probably use that for other court costs and fees if you are going to have them in another case. So 6-month imposed but stayed, 2 years probation, $1,500 in fines and fees. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. I need to make sure your address is still on Imperial Avenue.
Yes.
You haven't went back to, weren't you in Star Prairie or something?
Yeah, I was, but I'm no longer there.
Okay. So, and the telephone number is 6753, last 4?
Yeah.
Okay. Just because we have to make sure that we get the money back and we get that to you and or to Ms. Bruss, as I believe she did post the cash for you. I do need your DNA. You're going to need to make sure that you provide that to the jail before you leave. With this case, as it played out, you would be able to request your DNA be expunged through a written letter to the Wisconsin Department of Justice, not to me, the court, but to the Wisconsin Department of Justice. It's pretty easy to do. You can Google it and it shows you how to do that. I believe that covers everything. Nope, conditions, yes. Absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, regular drug testing, substance testing, any programming that your agent determines appropriate. I am going to tell you, you do have to report to probation immediately over here in Burnett County. They'd be able to transfer it and they can transfer it to Minnesota. You're going to need to pay $150. I don't think it's went up. So I think it's $150. I would pay it today if you have the ability to do that, because you only have like 7 days to be able to have it be transferred to Minnesota to pay that fee. So I'd take care of that today. So once you're done here, go give your DNA, go to probation, and then you should be good to go.
Okay.
Mr. Schmidt, what is the court missing?
Nothing from me.
Mr. Feliski?
Nothing further.
All right, well, good luck, Mr. Wagner. And I'm proud of you to see that you have made these changes in the last 2 years. I think that because I'm going to get, Ms. Bruss is your fiance, correct?
Yeah.
And I'm hoping that she is doing well as well. The last time I saw her, she was.
Yeah.
So continue down that path and stay away from people who will drag you down and bring you down this other negative path.
Yeah.
All right. We will go on the record in the matter 10 CT 108 12 CF 55 15 CM 144 15 FO 127 State of Wisconsin, County of Burnett versus Tracy Masuka. The state does not appear. This is a failure to pay return on warrant matter. Ms. Masuka, you were last in court back on April 3rd. No, it was in December 8th, 2025, when the court went over with you the amount that you still owe, the fact that I've given you various options as how to get this paid off, since it goes back so long ago. We're talking 16 years ago. And that you've made very few payments on the matter. The court went over whether or not you can do some community service and knock it off, what the court would be able to knock off. There are some that are mandatory that I'm not permitted to knock off. But we went over everything, and I have set it at the lowest of $50 a month, and that was there in December. From December to your review hearing on April 13th, in which you were supposed to come back to court, you were supposed to have made 4 $50 payments. As of April 13th, you only made two of those payments, and I believe it was for February and March. You did not make the December, the January, or then the April payment as of that time. Ms. Masuka, do you understand that? Oh, and then the court ordered 5 days of jail if you failed to abide by the court's ruling and order and make those monthly payments of $50. And you did not come to court on April 13th. Therefore, the court lifted the stay and issued a warrant for the failure to pay the 4 monthly payments of $50. And the 5 days of jail was then instituted with that warrant. Ms. Masuka, why did you not make your monthly payments of $50 per month?
I actually got tangled up and had overwhelmingly a lot going on. I totally forgot about it. Like you had said, it had been a long time and I've been irresponsible towards it. I did, however, think that one of those payments were made. I tried to get in touch with PayGov US, but they wouldn't or couldn't, whatever, give me a printout of all payments made during that time. So I wasn't aware of that one. And as far as missing court, I honestly thought that that review hearing was if I had missed a payment. And at that time, my head was so jumbled with everything else going on that I wasn't paying attention. I had overwhelmed myself with everything. I had emotional breakdown.
Ms. Masuka, do you understand that if you would have started making payments, if you would have started making the payments back in 2010 upon that first conviction of at minimum $25 a month, you would have had this paid off plus all of the interest, because you would have paid off from 2010 until now almost $5,000. And so you would have been paid off at $25 a month.
I wish I would have.
I highly and so much wish you would have too, because then you wouldn't have been here and you wouldn't be in this place. I'm going to tell you, unless I send you something that says that your hearing is canceled, you must be there. I don't set restitution hearings and go, well, maybe okay. I would still make you go. Perhaps you could have appeared by video conference, and then we would have went over and I would have said, okay, so it looks like you are making your monthly payments. We can set this out for a little bit further down the road. But that's not the case. And you have an extensive history of failing to pay or pay anything. You still owe almost $3,000. And so, I mean, I'm at a loss, and I don't want to have 5 days of jail every couple of months for you to be able to make your payments.
I definitely don't want that either. And Your Honor, I did try to get a loan to pay it, but I somehow got hacked, and now all my stuff is running right now. I have to get it all shut down, and just a mess. This turned into a huge mess, and I want to get it taken care of, and I will not miss any more payments or hearings. I honestly just was overwhelmed.
Well, I'm glad to hear that, because at $50 a month, that's the lowest that I am even prepared to go. I should order that it be at $300 or more a month to get this paid off, because the longer it takes you to pay it off, the more interest that accrues. And that means that you're probably never going to pay it off. So I'm willing to, I have a warrant for $1,000 out there right now. I'm willing to quash that, and I'm willing to start your payments back up again at $50 a month. And that would mean $50 to be paid starting in May and $50 thereafter. It shouldn't be that difficult for you to be able to do something to get at least $50 a month to pay towards these fines and fees. And so what I'm going to do is I am going to set another date and time, and we'll come back here. Yeah, we're going to take that one off. Your June 15th date is removed, and we are going to set another date and time. I'm going to schedule you for August 5th at 1:30. August 5th at 1:30. And you are to come to court, and I expect there to be a May payment, a June payment, and a July payment when you come back in August.
Absolutely.
And if you do not have those 3 months paid, and I'm not talking miss May and then pay 2 in June, or miss June and pay 2 in July. I want a May payment, I want a June payment, and I want a July payment, 1 in each of those months. You can pay more in each of the months, but it's not going to count and waive a payment for a different month. So you can pay $200 one month, but that won't count for your June payment. That won't count for your July payment. That'll just be extra money you're paying to pay down your fines and fees. If I do not have at least those 3 monthly payments, there will be another 5 days of jail. Do you understand?
Yes. Yes, ma'am.
All right.
Okay.
And as you can see, the court has the authority to issue warrants in cases like this because you haven't paid your fines and fees. Now, have you moved or have you not moved? Because I've heard differing versions.
I moved out of the apartment I was in and I am relocating. I don't have an address as of now, except for I'm staying with my sister currently until I can find another apartment.
And are you going to be living in Wisconsin?
Yes,
Okay.
it's a Shell Lake
So-
address.
With a Shell, you're going to be living in Shell Lake,
It's a Shell Lake address where I'm staying right now, yes.
but where are you looking to move to? Anywhere?
I'm thinking maybe Appleton, there's jobs. My youngest son goes there. I could go back to school next semester after I caught up a little bit of my money owed and get back on my feet a little bit better.
All right. Well, when you are released from custody, as part of your conditions, not only your $50 a month payment, but you have 48 hours from now to update the court as to a mailing address where we can send your mail, and to provide your telephone number. And upon any other relocation, if you're going to be moving to Appleton, you will have 48 hours from the time you move to Appleton to update the court as to your mailing address. Because I'm going to tell you, as you can probably see, warrants do extend other places.
Yes, ma'am. I do have
It
an
does-
address right now I can give you, so you don't have to worry about the.
Okay, your Shell Lake address? What is
Yeah.
that?
W7223 Lone Star Road. And it's Shell Lake 54871. And the number is still the same, 715-716-2259.
All right, that sounds good. And once you move from your sister's place, please call within 48 hours to update the court as to where your mail can be sent, and if you have any change in telephone number. And then we will go from there. I believe $50 a month is reasonable. It's doable. It's something that you should be able to pick up a babysitting job for one day and to be able to pay your monthly payment. The sooner you get this paid off, Miss Masuka, the sooner you get me off your back, and the sooner you do not have to worry about having to sit more time in jail.
Thank you.
All right, okay, well, then that is the order of the court. The court is quashing the warrant, and you do not have to pay that $1,000. And we will see you August 5th. At this time, it is an in-person hearing, If you have made every single payment and you have relocated to Appleton, you can write a written request to the court. Don't call and talk to my assistant. A written request to the court to appear by video conferencing, and I'll let you know if that is granted and approved, okay?
Okay,
All right.
thank you.
Thank you. We're adjourned.
These
We
two
will go on the
hearings highlight
record
an
in the
important
matter
reality of
24
the justice
CF
system.
119, State of
Every
Wisconsin
case is
versus
decided
Jeremiah
on its own
Wagner.
facts,
The state
the
appears
available
through
evidence,
District
and a
Attorney Kevin
person's
Schmidt in
actions
person.
before and
Mr.
after
Wagner
entering the
appears
courtroom.
in
In
person
Mr.
with his
Wagner's
counsel,
case,
Joel
new
Feliski.
evidence
We're set
significantly
today in
reduced
this
the
matter for a
seriousness of the
plea and
charges,
sentencing.
and the judge
Yesterday, we
ultimately
were here in
determined that
court
probation,
for a final
strict
pretrial.
sobriety
The court was
conditions,
informed of
financial
all of the
penalties,
information
and
that the
accountability were
attorneys are
more
aware of.
appropriate than prison.
District
At the
Attorney
same
Kevin
time, the
Schmidt
court made
updated
it
the
clear
court
that violating
based upon
probation could
information
still
he
lead to
received
jail
from
time.
Sawyer
In Ms.
County,
Masuka's hearing, the
another
issue
county
wasn't a new
connected
criminal
to
offense.
this case
It was
in
years
some
of
way,
unpaid
that
court
the
obligations and repeated
facts and the
failures to
evidence
comply
that
with court orders.
Burnett County
Rather than
has in order
immediately
to
imposing
try
harsher
Mr. Wagner
consequences, the
means
judge chose to
that
give her another
the possession with
opportunity,
intent
but with unmistakably clear expectations.
is not
Make every monthly payment on time, keep the
reliable
court updated, and
or
appear for
accurate
future
in this
hearings.
case
The
as
message
it
was
relates to
simple.
Burnett
Second
County and
chances
Mr.
come with
Wagner, and that
responsibility,
it is
and
just
failing
a
to follow the
simple
court's orders
possession
can
of
quickly lead to
methamphetamine,
serious consequences.
an I
These
felony
cases
case,
also
and
remind
that's all
us that
accurate and
courtroom
true, Mr.
outcomes
Schmidt.
are rarely as straightforward as headlines make them seem.
The
Judges
information
don't just
that
look at the
New
charge.
Richmond and
They
Sawyer were
consider
using
credibility,
and
accountability, rehabilitation, public
to
safety,
get their search
and
warrant, they
whether the law
exercised.
supports
They
the
actually
final
thought
decision.
Mr. Wagner
That's
and
why
Ms.
two
Russ were in
cases
St. Croix
involving
County.
very
They
different
didn't know how to use the
circumstances can lead to
GPS
very
equipment
different
correctly,
outcomes.
so they hadn't
Even when
updated
both
it.
defendants
They have
leave
no
the courtroom
explanation
with
for why
conditions
he
they
was
must
in
strictly
Washburn
follow.
heading into
What do you
Burnett
think
County.
about
They
these
were surprised he
rulings?
had meth
Did the judge
on
strike
him
the
when we
right
arrested
balance
him,
between
given the
accountability
meth they
and
thought they were
giving
going to
people a
find they
second
did find in
chance?
St. Croix
Or
County.
would you have
All
reached
the
a different
information that
decision?
when
Share
I
your
charged this
opinion in
case
the
and I was
comments
preparing to
below.
prosecute it,
We'd love
that
to
I
hear your
thought would show this
perspective.
was possession
If you
with
found this
intent,
courtroom
I thought
breakdown
was related to
informative
this
and as
quantity here.
compelling
It's
as we
not.
did,
It's for the quantity
make
found in
sure
St.
to
Croix
hit
County.
that like button,
Okay.
subscribe
So
to
this
the
is just
channel,
a possession
and
of
share this
methamphetamine,
video with
simple.
anyone
Yes.
interested in real
Okay.
courtroom
Formal motion
proceedings.
to amend
Thanks
count
for watching,
4
and
So
we'll
mad.
see you in the next courtroom
and count
breakdown.
5. Let's